Today, we all have assembled here for International Conference on Alternative Dispute Resolution, Issues and Challenges. Considering the docket explosion in India, it becomes incumbent for legal fraternity to adhere alternative dispute resolution mechanism. There are many kinds of dispute for which litigation can never be the solution. They can better be resolved through one of the ADR mechanisms such as arbitration, mediation, negotiation, and conciliation through Lok Adalat. This international conference on alternative dispute resolution is aimed not only to understand the importance and the scope of alternative dispute resolution mechanism in India, but as well as international perspective.
It's a mark of undying tradition to invoke Almighty at the beginning of an important event. Like a great philosopher once said, the function of prayer is not only to influence God, but rather to change the nature of the one who prays. We request our esteemed guests for lighting the lamp of knowledge. Please, sir.
Our Chief of Guests, Honorable Mr. Justice A.R. Dave, by presenting him a good luck plant. I would also request P.K. Malhotra Sir to welcome our guest of honor, His Excellency Major General Chris S. Eze, with a good luck plant.
I request Professor Dr. Pradeep Kulshrestha sir to welcome Dr. T.R. Naval sir, Chairman Lok Adalat, New Delhi, with a good luck plant. I request sir again to welcome P.K. Malhotra sir, former Secretary, Ministry of Law and Justice, with a good luck plant. I request Professor Dr. Pradeep Kulshrestha sir, Dean, School of Law, to deliver his welcome speech. Please, sir.
Former Judge Supreme Court of India, His Excellency Major General Chris S. Eze, retired High Commissioner of the Federal Republic of Nigeria, Honorable Dr. T.R. Naval, Chairman, Lok Adalat, Delhi, Shri P.K. Malhotra, former Secretary, Ministry of Law and Justice, and distinguished professor with the School of Law, learned participants, and my dear faculty colleagues, non-teaching staff, dear residents, ladies and gentlemen, a very warm good morning to all of you. It's my proud privilege to welcome all the esteemed guests on the dais and off the dais. We are privileged to conduct this international conference on ADR. The object of this conference is to provide a platform wherein we shall be debating and discussing various measures of ADR mechanism, and we shall be publishing a book also on the good papers which we have got. So after this inaugural session, we have two parallel technical sessions in the afternoon, wherein we have selected some good quality papers which shall be presented by the participants. I hope this conference shall lead us to better understanding of ADR mechanism. We need ADR because in view of pendency of the cases, ADR is the only way out. Honorable Justice A.R. Dave is a well-known legal luminary, and he has delivered many landmark judgments as judge of the different high courts, as Chief Justice of the Andhra Pradesh High Court, and as judge of the Supreme Court. He has always upheld the rule of law, and he has provided justice to a lot of people. We have with us His Excellency Major General Chris S. A.J. He is a very approachable diplomat and always provides solution to our resident whenever there is some issue. I am thankful to him that he was kind enough to accept our invitation and grace the occasion. We have with us learned Dr. T.R. Hon'ble. He was district judge in Delhi, and now he is looking after as chairman of Lok Adalats. He is also well known in Delhi judicial circles, and he is a very passionate judge. And I have seen many of his judgments, which are pro people and upholding rule of law. We have Shri P.K. Malhotra ji. He is associated with us since very long, and he provides the valuable input, and he guides us in all our legal endeavors. Thank you very much, sir, for helping us with our all these pursuits and endeavors. With these words, I'll cut short because we are following a very tight schedule. Justice Dave has to reach early. He has some prior arrangements. So otherwise, I can tell you voluminous things about our esteemed guests. With these words, I, on my own behalf and on behalf of the management, faculty colleagues, non-teaching staff, students, once again welcome all the esteemed guests on the dais and off the dais. Thank you very much.
His Excellency Major General Chris, High Commissioner of the Federal Republic of Nigeria, Dr. T.R. Hon'ble, Chairman, Permanent Lok Adalat Delhi, Professor Pradeep Kulsresht, all the faculty members, distinguished guests, and dear students. I think this is a very, very important day for the Sharda University when we are organizing an international conference on a very important and relevant topic, that is alternate dispute resolution mechanism. And we are privileged enough to have Honorable Justice Dave here to chair this inaugural session and share his thoughts on this important issue. He is the most appropriate person for us today to share his thought because as judge of the Supreme Court, he was also the executive chairman of the National Legal Services Authority, and under his leadership, I remember whenever the Lok Adalats were held, the number of cases which were disposed of by the Lok Adalat, if I tell you the figure is mind-boggling. And this is one way by which we have been able to contain the pendency in the courts. Otherwise, the pendency, which is now considered to be 3 crore plus in whole judicial system, would have been much more. Thanks to the Lok Adalat under his leadership and the judgments which he have rendered in arbitration matters in the Supreme Court, that we have been able to popularize ADR and reduce the burden of the courts. Thank you, sir. Thank you for accepting our invitation. And now, as all of you know, coming to the topic which we are discussing today, justice dispensation system is facing challenges in our country because of the large pendency. We have 3.2 crore cases pending in our country, and the number of judges, including in the lower court, district court, high court, and the Supreme Court, is around 16,000. And all the posts are not filled up. And one of the Kerala High Court judge has observed that if no new cases are filed and only these cases are to be disposed of, it will take us 100 years to dispose of all such cases. So in such a scenario, what is the alternative available to us? We have promoted alternate dispute resolution mechanism. It's not that the alternate dispute resolution mechanism in our country is a new concept. We are a very old civilization. If you look at the history of India, You know, the Panchayati Raj system is well entrenched in our country. Only thing is, it was given a little bit legal shape later on. But you look at our civilization, we have been deciding cases through Panchayati Raj system right from the very beginning. In addition to that, now under the Panchayati Raj system, now we have institutionalized it through various legislations. And now the mechanism which we have is not only arbitration, conciliation, and mediation, which is world over recognized. We have Lok Adalats also. In addition to Lok Adalat, even in the criminal justice system also, because the pendency is too large, we have come across and we have amended our CRPC, whereby we have introduced the concept of plea bargain. Although people say it may not necessarily be a real method of mediation, but I consider it as a method of mediation so far as the criminal justice administration system is concerned. We also came out with an act dealing with justice in villages, and the act is known as Gram Nyayalayas Act. We constituted Gram Nyayalayas. It was done in 2005. Idea was that when Gram Nyayalayas are there, people staying in villages need not come to the cities and spend their whole day leaving their job earning day, which while working in the field they can earn their livelihood, and they come to the cities and waste their time. So Gram Nyayalayas were constituted. But unfortunately, the Gram Nyayalayas has not been a successful experiment for the simple reason that initial support was given by the central government, funding was given by the central government for running the Gram Nyayalayas, and ultimately it was the state government which was supposed to have the financial burden for it, and unfortunately most of the states have not succeeded in providing that financial assistance for running these Gram Nyayalayas. In addition to that, if we are talking about the commercial world, because we are living in a global village, and now we are looking for foreign direct investment also. Now coming to the commercial world, these are the normal disputes which I was talking about. Now coming to the commercial world, if you are really looking for foreign direct investment, any person who is coming and want to invest money in India, he is coming here to do his business and earn profit. Nobody will do business for charity. So he also feels that once he has come here and invested his hard-earned money, in case there is a dispute, there should be an easy access to justice. But the kind of judicial system which we have, kind of delays which are taking place, probably he didn't have that kind of comfort. So to give that comfort, we changed and we came out earlier with an Act of 1940. But unfortunately, the Act of 1940 was not as successful as it was expected to be because of intervention by the courts at every stage of litigation, even at the time of appointment of arbitrator, for the purpose of passing an interim order, for the purpose of enforcement of award, declaring as a decree of the court. All these problems were multiplied, and I am reminded of the observations made by the Supreme Court in Guru Nanak Foundation case, where the Supreme Court observed on the working of the Act of 1940 that it makes the lawyers laugh and legal philosophers weep. In that scenario, probably then we moved further, and in 1996, the Parliament passed the Arbitration and Conciliation Act of 1996, which is based on UNCITRAL model and a model law which was approved by the United Nations way back in 1985, and we adopted it in 1996. Lot of changes were there, and this definitely gave comfort and cushion to an international investor so far as the ADR mechanism in India is concerned. He knew that now there is a system which is internationally accepted based on a model law passed by the United Nations, and probably comfort will be more. But unfortunately, when its working also started, probably what we did, we in our Indian country copied the UNCITRAL model law as it is, without applying much mind. This is my observation. Without applying much mind, that a law which is meant for international dispute resolution may not necessarily be suitable for domestic dispute resolution also. And the kind of distinction which was required to be made was not made. And then what happened? Again, there was a lot of intervention by the courts at different stages, and probably some of the interpretations which came from the judiciary were not as per the intention which was reflected or which was considered as appropriate when the law was made. So this all led to, again, Law Commission giving a further report, and the law was again amended in 2015. And this 2015 amendment, based on the recommendation of the Law Commission of India, brought many changes which have given a lot of comfort to the international investor to invest their money in our country. So far as ADR is concerned, I am again tempted to make an observation, quote an observation. It's not that it is India only which is facing this kind of difficulty. For dispute resolution, as easy dispute resolution, more particularly in the commercial world, I think we have to rely on the observations made by many leading personalities. And here I would like to make observations as I would like to quote Justice Mr. Abraham Lincoln, who said about litigation, because in the adversarial kind of litigation, what you feel, one party always wins, the other party always loses. But in ADR, in alternate dispute resolution mechanism, it is always a win-win situation. And in that context, the observations of Abraham Lincoln become important. And he says, and I quote, "Discourage litigation, persuade your neighbor to compromise whenever you can, point out to them how the normal winner is often a loser in fee, expense, cost, and time." Because, as I said, adversarial litigation is not the only mean of resolving dispute. And here again I am reminded of the observations made by Mahatma Gandhi, father of the nation, in his book, and which again become very relevant. And he said it more than 100 years ago. And what he said about the legal profession, when he was in the legal profession, "I had learned the true practice of law. I had learned to find out the better side of the human nature and to enter men's heart. I realized that the true function of a lawyer was to unite parties riven asunder. The lesson was so indelible, burnt into me, that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul." So if you are not going into adversarial litigation, but you are adopting ADR, it is a win-win situation for both the parties, and probably they can amicably work in future also. I think this all become relevant. And to promote ADR, even our system found that the law should also be amended, whereby even if a matter has gone to the court, is there a possibility that still settlement can be arrived out? Therefore, our CPC was amended, and section 89 was incorporated in the section that whenever a dispute comes before the court, the judge was mandated to see whether there is a possibility to resolve this particular dispute through an ADR mechanism, through arbitration, conciliation, mediation. And therefore, to promote this particular section, of course, its constitutional validity was challenged, saying that maybe once the dispute is there, parties have not agreed, only then they will come to the court of law. Therefore, this kind of provision cannot be made, that it should be struck down, let the court decide it. Court cannot make a reference to the for arbitration, mediation, or settlement, because there are other laws dealing with it. But let me tell you very frankly, so far as mediation is concerned, which according to me is the most successful method of resolution of disputes, as on today in our country, we don't have any structured law which deal with mediation. Of course, with arbitration and conciliation, we do have Arbitration and Conciliation Act. For mediation, either it is a court-monitored mediation, or it is a mediation which is coming under section 89, or in the new legislations which are now coming, we are moving in that direction. And one example is the Insolvency and Bankruptcy Code of India, which was passed by the Parliament, because there, of course, before the company can go for insolvency, there is an insolvency resolution professional who is mandated that to have a meeting with the committee of creditors and see whether there is a possibility to revive the company and the company can continue. So this has been inbuilt through legislation or through judicial intervention. And I must tell you, I must share with you, the mediation centers, more particularly because I know in Delhi and Bombay, where I have visited and I have seen, they are working very successfully, and most of the disputes are settled through mediation. Mediation can again be of two types, as all of us know. One is, of course, between the parties, where the mediator doesn't impose as well, and he only brings the parties to a platform to come to an amicable solution among themselves. He only oversees, he only coordinates. And the second is court-monitored mediation. And in our country, I think court-monitored mediation is more popular as compared to the individual mediation. Now, in addition to this, in our country, we have adopted certain novel methods in the law itself. Now, for commercial disputes, take for example, there are many regulatory bodies functioning in our country. For the securities market, we have SEBI. For insurance sector, we have IRDA. For pension sector, we have Pension Regulatory Development Authority, and of course, the Insolvency and Bankruptcy Board of India. Now, they also regulate the professionals, and those professionals are supposed to follow certain norms when they are doing their duty. Now, if these professionals commit any mistake, they can also be prosecuted, action can be taken against them. But in all these legislation, a provision has been made that in case a person has committed a violation of the regulatory framework, then a consent mechanism has been inbuilt.
Students, distinguished guests, ladies and gentlemen, Mr. Malhotra has given you so many things about the ADR. I will emphasize on arbitration, conciliation, mediation, permanent lok adalat and lok adalats. What is ADR? Alternate Dispute Resolution System. It was conceived of as a dispute resolution mechanism outside the code of law established by the sovereign or the state. In this sense, it included arbitration, conciliation, mediations, and all other forms of dispute resolution outside the court of law which would fall within the ambit of ADR. In arbitration, there is a final and binding award whether the parties consent to it or not, but in other form of ADR, there would be no finality except with the consent of parties. In arbitration, one party win and others may lose, both may lose, as in court case. In ADR, it is win-win situation because the parties would agree to a disposal of a matter on terms comfortable to each other. In this sense, in ADR, it is not the dispute or difference between the parties that is addressed, but the mindset of the parties, so that with gradual change in the mindset, eventually both sides come to a meeting point. The most practical forms of ADR in this sense are conciliation and mediation. Conciliation and mediations are often used as interchangeable terms, although there is a subtle difference between the two. In both the terms, the conciliator or mediator, often known as neutral, endeavors to bring both sides closer to each other, but in one he plays a more proactive role, whereas in other his role is only to enable the parties to come closer to each other, and for that purpose, at times the word facilitator is used instead of word neutral. In India, ADR has an important place because of historical reasons. Preamble of our constitution reflects importance of justice as justice, social, economical and political. Article 39, capital A of the Constitution provides for ensuring equal justice, equal access to justice. Administration of justice involves protection of innocent, punishment of the guilty, and satisfactory resolution of disputes. Why ADR? It has been rightly said that an alternative effective requires not only that just result be reached, but that they be reached swiftly. Presently, available infrastructure of courts in India is not adequate to settle the growing litigation within reasonable time. A common man may sometimes find himself entrapped in litigation for long as lifetime, and sometimes litigation carries on even on the next generation. In this process, he may lose his resources apart from suffering harassments. There is a chain reaction of litigation process, and the civil cases may even give rise to criminal cases. Everybody knows that courts are burdened with larger number of cases, congestion in the court rooms, lack of manpower and resources, delay, cost, procedural drawback requires the need of better options, approaches and avenues. A speedy disposal of cases and delivery of quality justice is an enduring agenda for all who are concerned with administration of justice. Alternate dispute resolution mechanism is one of the methods to lessen the burden on the courts. ADR serve the citizens to settle their cases promptly and quickly, and in this way ADR system provides speedy justice to the litigants. efforts towards ADR were met with considerable success and good results everywhere in the world, especially in the litigation, have supplemented the dispute resolution and adjudication process. ADR is not a current phenomena, as the concept of parties settling their dispute themselves or with the help of third parties is very well known to the ancient India. The dispute were peacefully decided by the intervention of coolage, family assemblies, Sirinivis, guilds of men of similar occupation, parishad, etc. There are various provisions that give the power to the court to refer dispute to the mediation. Such provisions inter alia are in the Industrial Dispute Act, Hindu Marriage Act, and the Family Courts Act. ADR has obtained a statutory recognition in the terms of CPC Amendment Act 1999, the Arbitration and Conciliation Act 1996, the Legal Services Authority Act 1997, and the Legal Services Authority Amendment Act 2002. The other provisions in CPC, which include Section 80, Order 32 capital A, Rule 5B of Order 27, also strengthen the ADR system. Access to justice is a human right, and fair trial is also a human right. In some countries, trial within a reasonable time is part of human right legislation. In our country, it is constitutional obligations in terms of Article 14 and Article 21. Industrial Dispute Act 1947 provides the provisions both for conciliation and arbitration for the purpose of settlement of disputes. Section 23(2) of the Hindu Marriage Act 1955 mandates the duty on the courts that before granting a relief under that act, the court shall in the first instance make an endeavor to bring about a conciliation between the parties where it is possible according to nature and circumstances of the case. The Family Court Act 1984 was enacted to provide for establishment of family courts with a view to promote conciliation in and secure speedy settlement of dispute relating to marriage and family affairs, and for matter connected herewith by adopting an approach radically different from that of ordinary civil proceedings. Section 9, Clause 1 of the Family Courts Act lays down the duty of the family court to assist and persuade the parties at first instance in arriving a settlement in respect of subject matter. The Family Court Act, with the assistance of the counselor, are effectively resolving the dispute of the litigant public. Section 80, Clause 1 of the Code of Civil Procedure lay down that no suit shall be instituted against government or public office unless a notice has been delivered at the government office stating the cause of action, name, etc. The object of Section 80 CPC is to give the government sufficient warning of the case which is going to be instituted against it, and the government, if it so wished, can settle the claim without litigation or afford a restitution without recourse to a court of law. Section 23, Rule 3 of CPC is a provision of making a decree on any lawful agreement or compromise between the parties during the pendency of the suit, which claim is satisfied or adjusted. The scheme of Rule 3 of Order 23 proves that if the court is satisfied that a suit has been adjusted wholly or partly by any lawful agreement or compromise, the court shall order such agreement compromise to be recorded, and it shall pass a decree in accordance to that. Order 27, Rule 5B confirms a duty on the court in suit against the government or a public office to assist in arriving at a settlement. Order 32, Clause A, capital A of CPC deals with suits relating to matters concerning the family. It seeks to highlight the need for adopting the different approach where matters concerning a family are at issue, including need to bring about amicable settlement. These provisions apply to all proceedings relating to family like guardianship, custody of minor, maintenance, wills, succession, etc. Rule 3 imposes a duty on the court to make an effort for settlement by way of providing assistance where it is possible to do so. In discharge of this duty, the court may take assistance of welfare expert who is engaged in promoting the welfare of the family. The concept of employing alternate dispute resolution has undergone a sea change with the insertions of Section 89 CPC by amendment in 2002. As regards the actual content, Section 89 of CPC lays down that where it appears to the court that there exists an element of settlement which may be acceptable to the parties, the court shall formulate the terms of the settlement and give them to the parties for their comment. On receiving the response from the parties, the court may formulate the possible settlement and refer it to either arbitration, conciliation, judicial settlement, including settlement through lok adalats or mediation. As per section 2 of section 89, when a dispute is referred to arbitration and conciliation, the provisions of Arbitration and Conciliation Act will apply. When the court refers the dispute to lok adalat for settlement by an institution or person, the Legal Services Authority Act 1987 alone will apply. Supreme Court starting issuing various directions so as to see that public sector undertakings of the central government and their counterparts in their states should not fight their litigation in court by spending money on fees or consuls, court fees, procedural expenses, and wasting public time. Oil and Natural Gas Commission versus Collector of Central Excise and Chief Conservation of Forest versus Collectors are some cases. In the judgment of Supreme Court of India in Salem Bar Association versus Union of India, the Supreme Court has directed to prepare model rules for alternate dispute resolution and also draft rules for mediation under section 89(2)(d) of the Code of Civil Procedure. The rules were framed and called as Alternate Dispute Resolution and Mediation Rule 2003. Rule 4 of the Alternate Dispute Resolution and Mediation Rule 2003 laid down that the court has to give guidance to parties when parties are opting for any mode of ADR by drawing their attention to the relevant factors which party will have to take into account before any exercise their opinion as to particular mode of settlement, namely, it will be to the advantage of parties so as time and expense are concerned to opt for one of those modes of settlement rather than seek a trial on the dispute arising in the suit. Where there is no relationship between the parties which requires to be preserved, it will be in the interest of parties to seek reference to the matter to arbitration. Where there is a relationship between the parties which requires to be preserved of resolving their dispute, that is not possible in public, formal and adversarial justice system perceived by to be dominated by the obstruse procedure and recondite language of law. It offers choice of method, of procedure, of cost, of representation, of location, because often it is quicker than judicial proceedings. It can ease burden on the courts. Because it is cheaper, it can help to curb the upward spiral of legal cost and legal aid expenditure too, which would benefit the parties and the taxpayer.
I usually plead with the person to speak softly because it is difficult for me to follow, So, and I know that it goes two ways. So I'm going to be, just as it's sometimes difficult for me to follow Indians when they speak, I also assume that it might be difficult for you to follow when I speak. So because of that, I'm going to be very slow and take my elocution very deliberately so that you can understand what I'm saying. His hand and asked a question which totally baffled the guy who was supposed to have presented the lecture. And then the guy said, oh, do you call yourself a professor, and this is something that my driver would easily answer. So he now called Einstein, who was acting as the driver, to come and answer the lecture. So why do I remember this story? I remember the story because there's a technical section that is going to follow this presentation. So by the time you people go to technical section and then become technical lawyers, I may have given the lecture, but I might behave like Einstein's driver. So thank you very much. Well, the paper that I have here is called Alternative Dispute Resolution and a Multi-Door Courthouse in Nigeria. Now, I am going to speak to the paper because a whole lot of what is contained in this paper has been so brilliantly covered by the two people before me. In fact, I have learned more sitting here in the last 20 minutes that I've known about law for a very long time. And I thank the prof and the guy who presented after him. Specifically, the importance of transparent judicial processes in our present state of economic development. It was the dean that was talking about that importance for the purpose of foreign direct investment. I got you right? But that's what I thought you were talking about.
Sir was Chief Justice of Andhra Pradesh High Court and the Bombay High Court. I hereby invite Sir to address the gathering. Please, sir.
His Excellency Major General Chris, Mr. Malhotra, Dr. Naval, Dr. Kulshrestha, respected teachers of this university, dear friends, ladies and gentlemen. I'm really very happy to be here in this Sharda University. The reason is that whenever I go to any school or college, I always used to say that this institution is like a temple of Ma Saraswati. Now here, in fact, it is a temple of Ma Saraswati because Ma Saraswati is sitting there. So I'm really very happy that we all, not only you students, but I wish that Ma Saraswati may bless us also, the teachers also, everybody. I can say one thing in this temple of Ma Saraswati. Very often I used to give a comparative idea that Ma is there. Ma means mother. We did it, she's Ma Saraswati. Saraswati is called goddess of education. That's why we lit the lamp there. And the reason for taking out shoes was that whenever we go to temple, we take out shoes. But it's all right, don't worry, there is no problem. But as there is written, that's why we removed the shoes. I think all teachers, I mean, don't mind if I say the word teacher instead of professor because they are all basically teachers, guru. They are the archaks or pujaris. They do puja for the students, and what students get is a prasad of knowledge. So I'm sure that you all students will be getting a very good prasad with help of your very competent teachers. And I'm told that the faculty here is really very good. And I'm sure that the students will take due advantage by taking more and more prasad and exploiting the teachers by putting several questions, relevant or irrelevant, and learn a lot from this university. The subject today is with regard to ADR. It's a very interesting subject and very important subject. I don't think this is a new subject for us. So far as we Indians are concerned, we had our Gram Panchayats. You know it very well. Gram means village, sir. I'll be just telling you something with regard to Gram is a village. In good old days, the practice in India was that in a village, there would be few senior persons, old age persons, very wise persons. They would be assembling. We used to say Gram Panchayat. Gram means village, Panchayat means 5 persons sitting there. And whenever there used to be any dispute in the village, the dispute would be taken there. Say A and B have some problem, then A and B would be going to that Panchayat. Those wise people, elderly people, respected people, they would not be biased. They would not be doing undue favor to anybody. People had trust in them. And the dispute would be produced before, facts would be placed before them. And that body will give the judgment. There might be law, there might not be law. They would be using their sound common sense and they would be deciding something, and that decision was final. There is no question of any appeal. People would be happy to receive the decision. It might be against me or it might be against you. But we will accept it because some senior persons of our village, very respectable persons, they have given some conclusion, they have given some decision, therefore we respect and therefore we accept. That was the tradition in our country. Unfortunately, that tradition was stopped, possibly because Britishers came and there was a development in law. Law became very complicated. Now the difficulty is, once again, we have to bring that ADR here for the reason that we are unable to cope up with the work. Number of judges in our country is very less. We have hardly 1/3 of the judges which we in fact require. On the other hand, you see population is increasing. 33 crores at the time when we became independent, it is about 125 crores today. One, judges number same. Number two, people are now more educated. They are more conscious about their right. If I fall down here, I would immediately find fault with the contractor. I said that those steps, riser is not proper. It should have been there are 6 inches and there is 8 inches. So I fall down. Formerly, nobody would think about that. But today, somebody might go to Consumer Forum and he said that this building has not been constructed properly. Where is the contractor? Where is the builder? Bring him here and I'll file a suit. This is because of the education. Next thing is trade and development. Now we have got several activities. So many things are there. Had I been here before 100 years, I would have been standing there with a megaphone perhaps. But today I have got a mic. Today I've got so many things. Today I've got wristwatch for I was not having before 100 years. I mean symbolically whosoever might be having wristwatch must be a luxury at that time. So we have got so many new things. We are manufacturing so many things. We are entering into so many contracts. Laws are complex. Company law, labor law. Now if I want to stop my office, if I am running a factory and if I want to close my factory, now naturally in normal circumstances I would go and close my factory. No, that cannot be done because now the law says that before closing down your factory, you have to take permission from the concerned authority. So that is a must. Now nobody would ever know that, okay, if I'm doing business, I don't want to do business, I don't do business. Why should I go to somebody? But that is a law. So the laws are so complicated, so many that even lawyers don't know, even judges do not know. I'm sorry to say, in fact, judges do not know because we know it only because two competent lawyers help us. Otherwise, it is very difficult. So all these factors created a problem for us. Our judiciary is unable to cope up with the work which is pending with it. That's why we brought this concept of ADR. Now you see there are 3-4 things with regard to that. First is arbitration. Second is conciliation and mediation. We may join both. There are differences. Some say that conciliation is different, mediation is different. Some say ultimately both is same. Let us not go into that. Then another thing is lok adalat. Lok means people, sir. Lok means people and adalat means court. People's court. We are having another concept. So these are the main important things. Now let me say something about arbitration. Arbitration is very important. Now we are concerned with international problems today. Here I saw that we are concerned with international problems. Now in case of arbitration, suppose there is no arbitration. Let us imagine one issue. One person from India places an order for purchase of diamonds from Belgium. Communication by email. Diamonds are to be delivered in Nigeria and payment is to be made in America. One Anil in India, Mr. Bipin in Belgium, delivery to be given to Mr. Somebody in Nigeria, payment is to be paid, Mr. Nizam, that's right, and Mr. somebody making payment from America. Now there is some dispute. Either with regard to delivery of diamonds or with regard to quality of diamonds or with regard to time of delivery, anything. Now where the suit is to be filed? Where action should be taken? Which court? I do not know, but nobody thought about contract. You see, I am in here, you are a Belgian, I said, you are my good friend, come on, send me 10 diamonds, give it to my wife who is in Nigeria right now, and my friend in America will make the payment to you. We don't enter into contract. This is the only thing which we exchange on email. Now tell me, suppose you don't deliver or deliver less diamonds, what to do? Where to go? Honestly, though I was judge for 20 years and 20 years lawyer, I do not know, unless the lawyer helps me that what is international law, I would not be in a position to say so. So better course is arbitration. The moment you enter into such a contract, you also have a clause with regard to arbitration. You say, suppose there is any problem. If there is any problem, then we will go to Dr. Naval. He is a good friend of us. He deals in diamonds. He knows what are the practices. He knows how business in diamond is done. He knows everything because he is also one of the dealers. So we said that, okay, agar problem hoga na, Naval, you take care. Now in such a case, no matter where goods were delivered, no matter from where payment is to be made, no matter where the buyer stays, no matter where the seller stays, the problem will go to Mr. Naval, Dr. Naval. Now Dr. Naval is an arbitrator. Now you see, look at the advantages. You are forgetting the legal provisions right now. You are not into that complications. Otherwise, to decide as to where suit should be filed, that process would have taken 5 years. Now here you know that Dr. Naval is there. Secondly, Dr. Naval is not a normal judge. He is not a normal person. He is a person who knows how the business in diamond is transacted. He knows techniques of business. Every business has got its own techniques. Say share market. You know when the shares are to be delivered, when payment is to be made, how the shares are to be given. All these things are known only to share brokers. We may not know. So here is an expert. Normal judge may not be expert. Judge becomes expert because two lawyers infuse some knowledge with regard to the subject in the mind of the judge. I might decide something with regard to how to prepare rasgulla. Rasgulla is a sweet. Now, suppose there is a matter with regard to preparation of rasgulla. Now, actually, except eating rasgulla, I know nothing about it.
The question is about the judicial role in the arbitration process. Nigeria, it has been limited, like, the major problem which limits Nigeria's attractiveness in the arbitration is the fact that.
But from the paper, I was saying that the legal enactments that have already been done in Nigeria to strengthen the hands of the courts in administering the alternative dispute resolution, that they are comprehensive in the case of Lagos. They are also comprehensive in the case.
I request Professor Dr. Pradeep Kulshrestha sir to present a token of our appreciation to Dr. T.R. Naval sir. Again, I request Professor Dr. Pradeep Kulshrestha sir to present a token of our appreciation to Sri P.K. Malhotra sir, former Secretary, Ministry of Law and Justice and Distinguished Professor, School of Law. I would like to call on stage Dr. M.C. Mehanathan sir for the vote of thanks.
The dignitaries on the dais, the dear participants, wish you all a very good afternoon. What a wonderful participants by all the dignitaries who have presented their views. I thank the chief guest of the day, Honorable Mr. Justice A.R. Dave, for his wonderful, presentation, and also, accepting our request to be here and to head the ceremony today, that is, the presentation today. Sir, our sincere thanks on behalf of the Sharda University and also the School of Law, Sharda University. Then I thank the guest of honor, His Excellency Major General Chris Eze. I remember, the day we went to him, we made a request to him, sir, please, do come and, that is, graces. His Excellency was so kindful. He readily accepted our invitation, and he has been here, and he had made a very wonderful, presentation. His Excellency, we are very, very thankful to you. The guest of honor, T.R. Naval, the chairman of Lok Adalat, New Delhi, he has made a very wonderful presentation about what is the present law about this important aspect. Sir, we thank you very much for your presence here, sparing your valuable time. Then I take this opportunity also to, of course, if I don't thank Mr. P.K. Malhotra, who made a very wonderful presentation. He has given the right that is perspective of the issue. Sir, I thank you. Although you are one among us, I take this opportunity to thank you for your wonderful presentation. Then the distinguished panelists have already arrived. I thank them for their accepting our request and be here. Then participants of the conference, without them, of course, the conference is incomplete. A lot of, there is no response we received. I thank all the participants and also the people who are with the, that is very good papers. I thank them. Then other invitees who are present, I thank them. Then the students who are here, that is very, since morning, showing a lot of interest, I thank them. Then I take this opportunity also to thank the wonderful teamwork shown by the Sharda, that is the faculty, particularly the co-colleagues, Amansi, then Jitin. So many people have worked hard. Then the student, the representatives who have worked day and night for the success of this event. I thank them all. Then the fraternity from Sharda University, who helped us to make this event a very successful event. Thank you all once again.